Hi everyone, I'm Ann Arceo, financial planner and founder of Savvy Duo Financial Planning, and I am here today with estate planning attorney Armine Bazikyan. Hi Armine.
Hi, Anne. How are you?
Great, and Armine is going to be talking to us today about estate planning, things like wills, trusts, selecting a guardian for your children. And what I love about working with Armine, that in addition to being a very talented lawyer, she was rated as a rising star by Super Lawyer magazine. She's also a super mom. So she has one child at home, another on the way, and she's really great at breaking down complex topics and making young couples feel comfortable and making these important decisions to make sure that their families are protected. So thanks, Armine, for joining us. We're really happy to have you here. Is there anything else that you'd like to add about your practice that I didn't mention in your introduction?
No, I mean, estate planning is what I do on a daily basis, day in and day out, so this is my area of expertise.
Great. And let's go ahead and jump into our Q&A. So first off, I think when most people have heard of wills, but I think when they think of estate plan, they feel like it's something that is for somebody older, for somebody wealthy. So can you just tell us what is an estate plan and why do I need one?
So an estate plan is comprised of several legal documents, and the entire objective of all of these legal documents is to take care of two situations that might come up in your life. Well, one of them, we know it will come up in your life. We know that everyone will die. So the first scenario that all of these documents envision and take into consideration is actual death. And the second is incapacity, if you're mentally or physically disabled and unable to take care of yourself. So an estate plan will basically dictate what your wishes are with respect to your family and your finances and your assets when it comes to being incapacitated, what you want done, and then what you want done after your death. So it's a series of documents, and they fall under this umbrella of estate plan.
I see. So it's not, an estate plan isn't just a will. There's several documents that make up an estate plan.
Definitely. And everyone's documents will be different based on every individual's needs and the individual's assets. So it may include a living trust. It may not, depending on whether that individual needs one or not.
I see. And at what point do you need to go and have an estate plan done? What happens in your life that would trigger you to need an estate plan?
Well, I always recommend having an estate plan as soon as you turn 18, because once you turn 18, you're no longer under the guardianship of your parents, and you need to make sure that you have certain documents in place that'll cover your finances and your health. So this will be a very basic estate plan, but it'll still be an estate plan nonetheless. An 18-year-old may not have any assets at all, but they will necessarily need a healthcare directive, for example. So once you turn 18, that's the age to basically have an estate plan in place, especially if the person is going away to college. It might be something that the parents might consider having done for their children. Make sure that they still maintain control over their health and they have control over their finances in case an accident should happen and the child might become incapacitated. But what you're looking for is major life events like marriage, the birth of a child, the birth of an additional child, acquisition of a major asset, a house, for example, if you purchase a house. But the focus should not be on the assets that you own. It should be on major life events. And I think marriage and children are two of the big life events that trigger a person to go out and look into getting an estate plan.
I see. So you recommend that everyone has one once they turn 18, even if it just consists of the medical power of attorney. If you may not have a home, you may not own a home or have a lot in savings, but you still need one for that medical power of attorney.
Definitely. I mean, I have clients who are older who have children that are going away to college, and that's one of the things that we do is once we eliminate the guardianship provisions that the parents have in their documents because they're no longer under their parents' guardianship, we definitely implement at the very least, a healthcare directive as well as a financial power of attorney for that 18-year-old, especially if they're going to be on their own, because the parent wants to make sure, and the child wants to make sure, that if something happens to them and they need their parent to step in and, you know, get access to a simple bank account that might have a few $1,000s in it, that it'll be an easy process. It won't be a difficult process. They won't have to go through, you know, they won't have to jump through hoops to get it done. And we want to make sure that, you know, they are definitely the person in charge of their health care, and that if the child cannot make their own decisions, that the parent is the person that's making this decision. So it's not necessarily replacing or taking away power from your 18-year-old. It's just making sure that if your 18-year-old can't do something for themselves, that you are the next person.
I see. And what happens if you don't have a medical power of attorney, or you know, you don't have a financial power of attorney, and you're incapacitated? What would happen?
So normally what would happen is your loved ones would scramble for a few days. They would try to figure out what they need to do as far as your finances are concerned. So let's say you're living on your own, you know, somebody has to step in and use their own funds to pay your rent and pay for everything that you need until they figure out how to have access to your accounts, where you keep your accounts, what you do with them. And to do that, the bank is going to require them to have custodianship, to have a conservatorship, excuse me, over your finances, and a conservatorship over your person physically, in order to make healthcare decisions. So your loved ones are going to have to go to court and seek a court order. And that's going to be a lengthy process. It's going to cost a lot of money for them, and it's going to be completely unnecessary when, you know, all along you could have just had these simple documents in place that would not have cost very much, and, you know, would not have made a big dent in your bank account, and it would have taken care of the situation from the get-go.
I see. And what about, so you're 18, you get these power of attorneys, and then you get married and you have children. How should your estate plan change once you have children?
So definitely when you have children, all of a sudden we switch the discussion to the main focus of the estate plan, which is a guardianship. We put the attention on guardianships because we want to make sure that, number one, the children are taken care of, and then everything else comes second, because as a parent, that's your number one concern all of a sudden. So what you would normally not have, you all of a sudden have, and that's guardianship provisions, which will detail exactly who will take care of your child and who will be the guardian of your child. And the guardian will be the person who, you know, makes decisions about your child's health care, your child's well-being, what preschool they go to, what school they attend, who they're friends with, when they can date, you know, all the things that you would normally decide for them.
And you just wrote a really great article about how tips on how to choose a guardian. Can you just summarize some of those tips? Because I know it's a really big decision, and a lot of clients stall because they can't decide who would take care of their kids. They can't even imagine that. Yeah,
and this is probably the most difficult part of an estate plan, is for parents who have minor children. What you want to do, and the reason why most people get stuck, is because they have multiple people that they're thinking of, and they just can't decide between a parent, the child's grandparent, or a friend, because they don't know when they're going to die, and that's the biggest problem. So I always recommend thinking in terms of 3 to 7 years. If your parent, you know, the grandchild's grandparent, is the ideal person in the next 3 to 7 years that you envision, go ahead and name them. Most people think that when they die, they visualize themselves being extremely old and their parents not being around, but that might not be the case. You might, you know, pass next year. And if your parent is around and you'd like that grandparent to take care of your child, go ahead and name them. And that brings me to my second advice, is you're always going to have alternatives. That's the number one thing you should have in your guardianship provisions. You should never name, you know, one person. You should name a second choice, a third choice, and a fourth choice, just in case that first choice does not, either they're not around or they just don't want to do it and can't do it. So name whoever you want to name for the next 3 to 7 years. And then reevaluate at that time. It's not a permanent choice. You can always change it to somebody else. So if you put a couple as, you know, a friend and the husband as your guardians, and then you decide, you know what, my child just doesn't hang out with them anymore, doesn't like to be with them anymore, they just don't fit into our family mold, you could go ahead and change it. It's not permanent by any means. And I would say think extremely practically. Think in terms of practicality for your child. If your child is used to a school district or a city that they're living in, don't name a sister or a brother that's living in, for example, Utah, where your child would have to be uprooted and moved to a completely different state and have to get used to a completely different set of friends and environment. So always think in terms of what's going to be most convenient for your child. And, you know, don't worry about your child's finances. A lot of people mesh the guardianship with money in their brains. You can name a different person to take care of the money for your child and a different person to take care of the well-being for your child, if that's the case and that's what you wish.
I see. And that kind of brings me to my next question. How often should people update their estate plan? So if they chose this guardian and, you know, that's maybe their parents, but their parents are getting older, you know, how often should they look back and update these documents?
So updating the documents is different from actually revisiting and reviewing your documents. I always recommend reviewing your documents at the very least every year, just to make sure that the trustees you've chosen, the guardians you've chosen, are still people in your lives that you would want involved in the process. As far as amending or, you know, revising the documents, that might not be necessary unless there's a major life event. So, for example, I provide free annual reviews to all of my clients where they'll come in and we'll spend about an hour to an hour and a half just going over their existing documents and just reviewing it and making sure that they're okay with who they've chosen. If we come across a trustee and they say, hey, that person has passed or is no longer involved in our lives, we want to definitely take them out, then that would warrant an actual change. If everything else, if checks out and they have no other life changes, then we might not actually make any solid changes to the documents at all. They can live off of the same set of estate planning documents for 5 to 10 years if they aren't the type of people that change people in their lives or have major life events going on. But revisiting annually is a must.
I see. That makes a lot of sense. And can you tell us, I know a lot of times, you know, people are familiar with creating a will, but a lot of times estate planning attorneys actually recommend having a trust in place. So what's the difference between a trust and a will, and why would you need a trust versus a will?
So we know that a will and a trust are both legal documents. The main difference is that when you create a will, it goes into effect when you die, and that's the only time that it goes into effect. Whereas when you create a trust, it actually covers another situation. It not only covers death, but it covers incapacity. A will is a legal document that you basically need because it tells the world what you want done when you're actually dead. The trust itself is something that goes into, it comes alive the day you sign it. And you can think of a trust like a corporation or an LLC, for example. It's a separate entity. And what you do is you transfer all of your assets out of your name and you put it into this bucket. I'll use bucket since you like using that term. You put it into this bucket called a trust so that at your death, you really have no assets that are in your name that need to go through probate because you had given it to this bucket years ago. So that leads me to the second difference is that when you have a will, you will go through the probate process in California, whereas if you have, you know, no assets that need to go through probate, then you're going to avoid it completely. So the trust actually is the backbone of a good estate plan, and it helps you avoid going through the probate process. You know, those are pretty much the main differences, is that we're focused on whether you will go through probate and what it covers. So the trust will cover incapacity, so you can actually plan for death and incapacity, whereas a will won't let you do that. It'll just allow you to plan for death.
I see. And does a trust, you know, not to get too complex, but does a trust require anything on an ongoing basis that you have to do to maintain the trust?
Other than making sure that all of your assets are in the name of your trust initially when you create it, there's nothing that you have to do as far as, you know, some people think they have to file, let's say, separate annual taxes for the trust or things like that. So if it's your living trust and it's a living revocable trust, you don't need to do anything additional. It doesn't add more responsibilities to your life other than having the name on your checkbook, for example, be the name of the trust rather than your name.
I see. So just making sure that all of your accounts and your assets are in the name of the trust is really the biggest part of it.
Exactly.
Great. Well then, okay, so once you decide that you need these documents, how do you go about finding a good lawyer? Do you need a lawyer to create these documents, and how do you find someone?
You definitely need an attorney, just like any other legal process, to create these documents. One simple word change or phrase in a document can change the entire meaning of the document. So definitely consult with an attorney that is somebody who specializes and does trusts and estates on a daily basis, because you want to make sure that you have all your dots connected and all your basically dominoes lined up. You have a ton of state regulations and laws, and you have even more IRS codes and federal laws that you're playing with. So you don't want to create a document at home on your own that's going to put everything at jeopardy. So you think you're saving money by not hiring an attorney, but it's going to cost your loved ones more money at the end. So you should definitely consult with an attorney for an estate plan. And the best way to do that is to ask for referrals from friends and family, because it's a very trust-driven process, and you want to make sure that you trust the individual that you're working with and that you like the individual that you're working with, because it does create a long-lasting relationship. So I always recommend liking everyone that you work with, but most especially your estate planning attorney, because you're divulging a lot of personal information and the person's getting involved in your family dynamics. So you need to make sure that you enjoy working with the individual.
Are there any, you know, if you ask around to your family and friends, like for me, we were new to this area and I happened to meet Armine. But if you're new to an area and you don't know how to find a good estate planning attorney, are there websites that can send you a referral to good attorneys in your area?
You know, just like anything else on the web, attorneys promote themselves on the web. I wouldn't necessarily go to the web as your first choice for finding an estate planning attorney. It might work if you're looking for, you know, a personal injury attorney that specializes in motorcycle accidents.
Mm-hmm.
But for estates and trusts, I definitely would recommend asking someone you know, whether it's a representative at the bank that you're banking at, whether it's your financial planner, whether it's your CPA. So some professional in your life will have a recommendation for you, even though you might not have friends and family in the area. So I definitely recommend asking people that you know firsthand versus going to, you know, the internet.
Yeah, that definitely makes sense. And once you have these documents created, where do you store them? Where do you keep them, and how do you let people know where to find them?
That's a great question. So I always recommend storing your original set in a safe deposit box, or if you have a safe at home that's fireproof, in a safe at home. And I always recommend letting the first person that you've named as trustee or executor, letting that person know where to go to find it. Whether it's leaving the combination to your safe in an envelope and saying, hey, if something happens to me, I want you to go to my drawer in my room and pull out this envelope that has your name on it, and it'll tell you what to do, or whether you feel comfortable just giving them, you know, the combination today and saying, hey, and trusting them to open it when they need to, not when they come over for coffee. So, definitely storing them in a fire safe place, and I also recommend keeping digital copies of everything on your computer just in case, and maybe having that as a first go-to for the person that's going to take charge once you're gone or incapacitated.
You mentioned storing them on your computer, and that brings me to my next question. What does it mean to have a digital will?
So digital obviously the digital world is taking over our lives. We're having a digital, you know, conversation, I guess you can say. We would normally do this in person and then record it on a videotape and then upload it and do all that, but we're doing it live on, you know, Google, thanks to Google. So the digital world, because of all the advancements, it's causing a little bit of chaos in the estate planning world in that attorneys don't have a clue as to how to handle it because there are no state laws that provide guidance in California. There's other states that have been proactive about enacting laws that deal with digital assets, but California is just one of the states that's still dragging their feet. So digital assets are things like Bitcoins, your Facebook account, a PayPal account. It can range from, you know, digital accounts that have sentimental value to digital accounts that actually have a monetary value for you. And so what we want to make sure as an estate planning attorney is that not only do we give instructions and access to your loved ones to assets that you have that we know about that you're going to get, let's say, an envelope in the mail for when you die from Citibank that you have an investment account with, for example, but that your loved ones will also know about a Scottrade account that you have, you know, on the internet that you will not necessarily get a paper invoice for or a paper mailer for. So what we want to do is we want to incorporate this somehow into your estate plan, and there's different approaches to how you do that, but you want to make sure that your estate plan covers your digital assets in one way or another. Whether that method will necessarily, you know, fly with the court or not, at least you'll have instructions and the judge will take that into consideration versus not having it at all. So for example, I provide my clients with a digital power of attorney that allows them to give somebody access to their digital accounts, as well as incorporate a digital trustee and a digital executor into the documents. That makes it clear that, hey, the people I've named as trustee of my trust should also be in charge of my digital assets, so that if they do need access and a company like, you know, PayPal says, okay, where's the authority for you to act on behalf of this person, they can point to the will and say, hey, I'm the digital executor as well. So you want to make sure that, number one, you leave a list of all of your digital assets so that we know where to find it. And number two, you've named the individual to be in charge of them and to take care of shutting down the account, withdrawing funds from the account, doing whatever they need to do to get things done.
I see. So really the first step is making a list, a good list of all the different digital accounts that you have, or maybe all the accounts that you have, period.
I say all the accounts. Yeah, so it's called, well, I call it a digital instruction, and it basically will list everything from your Facebook account to your iPhone, you know. Your iPhone, where do you keep it? Usually it's in my purse or it's on me physically. So if something happens to me, I want somebody to get in. And this is the security code that I have to get into my iPhone. I want you to, you know, take all my photos and upload them and give them to my daughter or give them to my husband. And I want you to delete everything else or make sure that my email accounts are deleted. And then you can have another account, Facebook. I want you to memorialize my account for all my friends and family to see forever and ever and ever. You know, and the good thing, for example, about certain service providers is that they've taken the initial steps to do something about it because the states haven't. So, for example, Google early last year came up with Google Inactive Account Manager, and what it does is it basically combines your YouTube, anything you have Google, so your YouTube, your Google Plus, your Gmail, all of these accounts, and what it does is it allows you to set an account manager on there to where you can actually get notified if your account hasn't been used in 6 months. So let's say you don't use your account for 6 months or 9 months or 12 months, whatever you put the setting to. It'll email you, it'll text you, and it'll say, hey, are you around or has something happened to you? And if you don't respond to that, it'll go into, you know, preservation mode, I call it. So it will email somebody that you designated or call them or text them and say, hey, this person's not responding. They're obviously not around. You're the person that they've put in charge. And it allows you to write a letter to that person that's more personal that says, hey, obviously I'm not around. Can you do me a favor and delete this account, or can you do me a favor and go into this account and take care of it for me? So it allows you to do a slew of things, and I think one of the best steps that a service provider has taken to make sure that their clients and their users are basically taken care of, and that they don't lose all of these important things that they have in their, business YouTube page, or, in their email account.
Yeah, that's really interesting. I didn't know that Google had that. That's a really interesting.
Yeah, so if you have any type of Google account, you should go in and search for inactive account manager, and you should go in and set it up, and instruct Google account manager to do with what, with your accounts, what it needs to, whether it's self-disintegrate in 12 months, or it's, let this person know that I'm not around so they can get in and print out all those love letters from your and hand it to them, or if you have pictures, CASA, that you're preserving those and you're kind of downloading them for your next generation, because normally we would hand the person an album at your death, right? Your kids and your grandkids would look at old pictures and say, okay, I'm taking this one, I'm taking this one, but nowadays it's all on the internet, and if you don't
know anyone who prints pictures anymore.
Yeah, if you don't store things and you don't tell them where to find it, people aren't going to know. So
yeah, that's really interesting. That actually gives me something to think about, like when you mentioned the iPhone, and
yeah,
people wouldn't know your passcode if something were to happen to you. So that's really interesting. And I think actually, Armine, you and I were talking about maybe doing a webinar in the future a little bit more in detail about this topic.
Yeah, definitely. It's a hot topic right now, just in general, but for estate planning purposes, it's something that I think is very important, especially for our generation, especially for planning with younger generation couples and individuals. It's something that we need to keep in the forefront. The older generation doesn't really have this problem because they might have just a simple email account, and maybe they'll have a Facebook account, but they don't care if something happens to it. Whereas, my generation, I have letters in there from my husband that I would kind of want kept as a member. It's the same thing as having a love letter from the person from when you were dating, for example. But in this case, it's an email back and forth. I have, YouTube videos of my daughter that I keep on a private page, so that's how we decide to store things. And if something happens, I would want her to kind of have access to it at the very least and be able to do whatever she wants to do with them.
Yeah, definitely. That makes a lot of sense, and that is really interesting. So everyone will have to stay tuned for when we do that webinar.
Definitely.
Okay, well, Armine, thanks so much for taking the time to answer all of these questions. I'm kind of putting you on the spot here, but do you have any additional tips? Can you kind of summarize, maybe 3 tips for people who are getting started with estate planning?
My first tip is work with somebody that you like and that you will enjoy working with, because it is a long-lasting relationship. So I always tell my clients during the meeting that, you're interviewing me and I'm interviewing you. If neither one of us gels very well with each other, it's probably not going to be good to move forward. So definitely like the person that you've chosen and that you're working with. Make sure that the person is someone who is an estates and trusts attorney versus someone who does it on the side, because there's a lot of law changes that happen in this field, and you need to make sure that the attorney you've hired is staying up to date with all the law changes and knows what's going on. And I think the second tip that I would give, or would this be the third one, I guess? Another tip would be, don't think that just because you don't have assets that you don't need an estate plan. An estate plan is solely for the purpose of easing the financial as well as emotional burden on your loved ones. It has nothing to do with what you have. And it has everything to do with easing everything for your loved ones and friends and family if something happens to you. So if you have people you care about and you would want to lessen the burden on them, whether it's financial or emotional, you need some sort of estate plan. Now, your estate plan, if you don't have a lot of assets or have no assets at all, might look extremely different than your friend who has, a house and some bank accounts. But nonetheless, you need some sort of planning for what happens if you're incapacitated and what happens when you die. So just like you would have, an emergency plan for, hey guys, if there's an earthquake, I want all of us to meet at this particular location. this is exactly what you're doing with your estate plan, is you're thinking about the future and you're saying, hey, if this happens, I want this done. And I think everyone needs to have that in place, whether you have money and a house and whatever you visualize or you don't.
Definitely. And Armine, if clients are in the LA area, people watching are in the LA area and they want to contact you to get more information on having you do their estate plan, how can they get in touch with you?
They can go to my website, which is www.bazikyanlaw.com. They can contact you, Anne, and contact you, and I'm sure you'll pass along the information. I provide free consultations to everyone, so they can definitely give us a call and set up a meeting and they can call 818-649-9110. Or they can go ahead and go through my website and email me, and they could just Google my name.
Great. Well, thank you so much. Thanks again for your time, and we really appreciate it, and I look forward to doing hopefully a webinar with you again in the future on digital assets.
Definitely. Thank you for having me, Anne. This was a lot of fun.
Great. Thank you. Thanks, everyone. Bye.